Ja, vielen Dank, Kai, für die Einladung. Es ist mir immer wieder eine Freude, hier in Göttingen zu sein. Ich war ungefähr 20 Jahre in Göttingen und habe in dem Gebäude nebenan, ich bin heute Morgen an meinem alten Zimmer vorbeigegangen, wo ich 3 Jahre lang an meiner Dissertation Theorie der juristischen Argumentation und 6 Jahre an meiner Habilitationsschrift Theorie der Grundrechte geschrieben habe.
Eso fue una introducción personal, diciendo básicamente que a él siempre es un gusto de volver a Göttingen, como es su alma mater, su universidad. Ahora pasó por la oficina donde escribió su doctorado, donde estaba encerrado 3 años, y también por la otra oficina donde escribió el postdoctorado 6 años, ¿no? Ustedes ven, es un sufrimiento. Y entonces para el profesor Alexy es siempre un gusto volver a su ciudad, conoce todo cuando lo invitamos al restaurante. Ich erzähle nur, du kennst alles noch, wenn wir dich zu einem Restaurant bitten, du kommst immer pünktlich. Si lo invitamos a un restaurante como ayer, solamente indicar el nombre y una vez yo lo dije, Herr Alexy, kennen Sie den Namen des Restaurants das erste Mal? Y él me dijo, ¿cómo me puede preguntar eso? Yo soy de Göttingen, yo conozco Göttingen. Und so gesagt, ich kenne alles. Conozco todos los restaurantes y bares de Göttingen. Bueno, pero vamos al tema serio. Jetzt die ernste.
Ich werde einen Vortrag halten, in dem ich die Grundideen meiner Gesamttheorie darstelle.
La presentación va a ser sobre la idea fundamental, la idea esencial de toda su teoría de derecho. Eso es condensado en este texto.
Ich habe in meinem Leben 3 Bücher geschrieben.
He escrito 3 libros en mi vida.
2 habe ich schon erwähnt, Theorie der juristischen Argumentation und Theorie der Grundrechte.
Los dos ya mencionados, Teoría de la Argumentación Jurídica y Teoría de los Derechos Fundamentales.
Das 3. Buch ist Begriff und Geltung des Rechts.
Y el tercer libro es el libro Concepto y Validez del Derecho, o Validad del Derecho.
In den letzten 20 Jahren habe ich diese 3 Bücher zu einem System verbunden.
Estos 3 libros en los últimos 20 años trató de conectar como un sistema.
Und dieses System will ich heute präsentieren.
Y este sistema quiero presentar a ustedes ahora.
Mein Thema ist the real and the ideal dimension of law.
El tema es la dimensión real y la dimensión ideal de derecho. Wie haben wir das letzte Mal gemacht? Du liest jetzt einfach, ich übersetze das nicht. ¿No? Él va a leer esto, yo no voy a traducir, porque va a ser en inglés. Ustedes tienen ese texto y cualquier pregunta después. Okay? Also liest du einfach.
Ja. Does law have an ideal dimension? Or can the concept and the nature of law be completely grasped by considering its real dimension alone? The dual nature thesis, my main thesis, the dual nature thesis, which stands in the center of my legal philosophy, sets out the claim that law necessarily comprises both a real or factual dimension and an ideal or critical one. The factual dimension concerns the law as fact, that is, as social facts. The social facts to which it refers are authoritative issuance and, second, social efficacy. The ideal dimension refers to correctness, primarily to moral correctness. If one claims that social facts alone can determine what is and is not required by law, this amounts to the endorsement of the positivistic concept of law. Once moral correctness is added as a necessary 3rd element, everything changes. Fundamentally, a non-positivistic concept of law emerges. Thus, the dual nature thesis in setting out the claim that law necessarily comprises both a real and ideal dimension implies non-positivism. Section 1, the claim to correctness. The Archimedean point of my thesis is that law necessarily has an ideal dimension, and the argument is the argument from correctness. The argument from correctness states that individual legal norms and individual legal decisions, as well as legal systems as a whole, necessarily, that's important, lay claim to correctness. The necessity of raising this claim can be shown by demonstrating that the claim to correctness is necessarily, again necessarily, implicit in law. For instance, I add something to my lecture. John Finnis, perhaps you have heard the name. John Finnis has argued against my theory that the law very often raises a claim to correctness, but it does not raise the claim necessarily in the American Journal of Jurisprudence. The best means of demonstrating its necessity is a method of performative contradiction. An example of a performative contradiction is the fictitious first article of a constitution that reads, imagine Germany makes a new constitution after the reunification, and the first article of the German constitution has the following wording: Germany X is a sovereign, federal, and unjust republic. It is scarcely possible to deny that this article is somehow absurd. The idea underlying the method of performative contradiction, as applied here, is to explain the absurdity as stemming from a contradiction between what is implicitly claimed in framing a constitution, namely that it is just, and what is explicitly declared, namely that it is unjust. Now, justice counts as a special case of correctness, for justice is nothing other than the correctness of distribution and compensation. Therefore, the contradiction in our example is not only a contradiction with respect to the dichotomy of just and unjust, but also a contradiction with respect to the dichotomy of correct and incorrect. What is more, in the aforementioned example of the fictitious first article of the Constitution, the contradiction that arises between what is explicit and what is implicit is necessary. Again, the word necessary. To be sure, it could be avoided if one were to abandon the implicit claim. But to do this would represent a transition from a legal system to a system of naked power relations. In other words, to something that is necessarily not legal system at all. That is my first chapter, claim to correctness. And I add, perhaps that the claim to correctness is very intensively discussed in the present literature. I had already mentioned John Finnis, who attacked my theory. Joseph Ratz attacked my claim to correctness thesis. You find his attack in the second edition of his book, The Authority of Law, in the appendix. And my favorite enemy and best friend is Eugenio Bouligin. He attacked me 20 years ago. I attacked his attack. He attacked some years later in Italy. He attacked my attack on his first attack. And I attacked his attack of my attack on my first attack, and so on. And in Girona, in Spain, we had a conference only some years ago. Again, we had our third round. And you can find these 3 rounds, 6 articles, in a book just published in Brazil. And we have also Paula Garrido has made in Argentina a Spanish translation, but only round 1 and round 2. And now she makes a new edition with also the third round. You see, I talked only some minutes on the claim to correctness. I could give 14 days lecture on the claim to correctness, but I will not do this. Okay, we go to section 2. The necessity of the real dimension of law. A closer analysis of the ideal dimension of law presupposes an analysis of the real dimension. Here again, the concept of necessity enters the stage center. The starting point is the idea of pure ideality. A purely ideal system of reasons for action would be a system based on nothing other than moral and prudential reflection, rational practical discourse, and spontaneous compliance with the results of reflection and discourse simply owing to their correctness. Such a system, such an ideal system, we could also say such an anarchistic ideal system. Such a system would be deficient for 3 reasons. Thank you. The first is a problem of practical knowledge. There are a great many practical questions in which no agreement can be arrived at, not even between reasonable persons. John Rawls calls this reasonable disagreement. That makes legally regulated procedures necessary, procedures that guarantee the arrival at a decision which determines what the law is. This implies the necessity of authoritative issuance as social fact. You see, I am a non-positivist, but the positivistic element in law is very important for me. Therefore, dual nature thesis. The second reason is that spontaneous compliance is not enough. If everyone could violate the rules authoritatively issued without any risk, the rules would lose their social efficacy. Therefore, their enforcement is necessary. This necessity includes coercion, incorporating it into the concept of law alongside with correctness. Determination and enforcement are to be completed by means of a third reason. Numerous needs and purposes cannot be satisfied by spontaneous action alone. Organization is necessary. And organization presupposes law. For these three reasons, the deficiency of the ideal dimension is conceived, if conceived as a purely ideal system of reasons alone, leads to the necessity of positive law. That is, to the necessity of the real dimension. This necessity, however, does not stem from positive law. It stems from the moral requirement of avoiding the costs of anarchy and civil war and achieving the advantages of social coordination and cooperation. That was section 2, the necessity of positive law or of the real dimension. Section 3, first order and second order correctness. One might assume that the necessity of positivity implies positivism. This, however, would be incompatible with the claim to correctness. To be sure, the moral necessity of positivity implies the correctness of positivity. Ah, hi, Rogerio. Rogerio just comes from, my friend from Brazil, just comes from Rio de Janeiro. Yes? Okay, we will meet. Yes.
He comes late.
Yes. To be sure, the moral necessity of positivity implies the correctness of positivity. But the correctness of positivity does not by any means implies that positivity is to be understood as having an exclusive character. To grant positivity an exclusive character would be to fail to take account of the fact that the claim to substantial correctness, first and foremost, the claim to justice, does not vanish once law is institutionalized. It remains alive, standing behind and found in the law, and it is the main task of the theory of the ideal dimension of law to make this explicit. In order to achieve this, one has to distinguish two stages or levels of correctness. First order correctness and second order correctness. First order correctness refers only to the ideal dimension. It concerns justice as such. Second order correctness is more comprehensive. It refers both to the ideal and to the real dimension. This means that it concerns justice as well as legal certainty. Legal certainty, however, can be achieved only by means of positivity. That is, by determination, enforcement, and organization. That were the three arguments in the last chapter. In this way, the claim to correctness, qua second-order claim, necessarily, again, you see my most favorite concept, the concept of necessity. Without the concept of necessity, we can have, that's my thesis, no philosophy. Necessarily, the claim to correctness necessarily connects both the principle of justice and the principle of legal certainty with law. The principle of legal certainty is a formal principle. It requires commitment to what is authoritatively issued and socially efficacious. The principle of justice is, first and foremost, a material or substantive principle. It requires that the decision be morally correct. Both principles, as principles in general, can collide, and they often do. Neither can ever supplant the other completely, that is, in all cases. On the contrary, the dual nature of law requires that they be seen in correct proportion to each other. Thus, second-order correctness is a matter of balancing. This shows that balancing has a role to play not only in the creation and application of law, that is, in legal practice, but also at the very basis of law. It is part of the nature of law. That was section 3. Now we go to section 4, the ideal dimension pentagon. Now we are ready to give a closer determination of the relation between the real and the ideal dimension of law. In order to do this, we have to answer 5 questions. First, is there an outermost border of law? Second, is legal argumentation based exclusively on authoritative reasons, or does it also include non-authoritative reasons? Third, what is the relation between human rights and legal systems? Fourth, is democracy to be understood exclusively as a decision procedure or also as a form of discourse? Fifth, do legal systems comprise only rules expressing a real ought, or also principles expressing an ideal ought? These 5 questions shall be answered with the following 5 theses. The first with the Radbruch formula, the second with the special case thesis, the third with the thesis that constitutional rights are to be understood as attempts to positivize human rights, the fourth with the deliberative model of democracy, and the fifth with principles theory. All 5 theses turn on the same point, the claim to correctness. Perhaps I can use this piece here. Ja, okay. Wir haben schon dabei. Ja, perfekt. We already have the pentagon there. All 5 theses turn on the same point, the claim to correctness. That is the center of the whole one. Claim to correctness. And all 5 theses are implications of the claim to correctness.
Kannst du weiter auch hören? Sie verstehen dich auch ohne Mikro, wenn du jetzt hier laut.
Ja. Therefore, if my claim to correct the thesis would be wrong, everything would break down. Therefore, the claim to correct the thesis is so important. My text could think about drawing a pentagon with one thesis found at each edge, and the argument from correctness like a sun standing in the midst. This visualization one might call the ideal dimension pentagon. Can, however, only be seen as a heuristic model of a system of the institutionalization of reason that is to be elaborated by means of arguments determining the relation between the real and the ideal dimension in 5 directions. And I add a remark. I have developed the ideal dimension pentagon 2 or 3 years ago at a conference in Calabria, in Catanzaro, organized by Massimo Latorre. And when I wrote the first time about the ideal dimension pentagon, you must know, all my writing, nearly all of my writing is in English, and I have the great good luck that my friend Stanley Paulson, perhaps you have heard the name, the greatest Kelsen specialist in the world. He is my guest since now exactly permanent guest, 20 years in Kiel. He had a rule, I have still 2 rules at the Kiel University, one for Stanley, one for me. And he is my English teacher. And when he got my paper, in which I wrote about the ideal dimension pentagon, Stanley said, he comes from the Washington University in St. Louis in the United States. He said, Robert, you have become crazy. Do you know what the Pentagon is in Washington, D.C.? I cannot agree with you if you try to use the expression ideal dimension pentagon. Find another term. But some days later, he came to me and said, Robert, I have thought about the ideal dimension pentagon. And I think now you can use the term. For we have in Washington, D.C., the real dimension pentagon. And would be good to have as an opposite to the real dimension pentagon, the ideal dimension pentagon, orientated on justice and correctness. Okay, that is, and now the 5 elements. First, the Radbruch formula. The first direction concerns the idea of an outermost boundary of law. The most renowned version of this thesis, namely that such an outermost boundary exists, is the Radbruch formula. In its shortest form, it runs as follows, very short form. Extreme injustice is no law. I repeat, extreme injustice is no law. The German courts applied this formula after the breakdown of the Third Reich after 1945. then the German courts again, after the end of the German Democratic Republic, especially the killing at the walls, and the Argentinian Supreme Court has applied ideas of the Radbruch formula some years ago when they declared the amnesty laws. Have you ever heard about it? The amnesty as null and void from the beginning. And then they even quoted me in their decision applying an element, very unclear decision, element of the Radbruch formula. And there are other courts too. The Radbruch formula is an expression of second-order correctness. Now we come into the system. Second-order correctness refers to both the real dimension as well as the ideal dimension of law. The central concern of the real dimension is legal certainty, arrived at by means of positivity. That is to say, by determination, enforcement, and organization. By contrast with this, the central concern of the ideal dimension is substantive justice. In this way, the claim to correctness necessarily connects both the principle of justice and the principle of legal certainty with law. Second-order correctness requires that the problem of unjust law be resolved by means of balancing. And we have in all society unjust laws. The claim to correctness requires that this balancing leads to the result that below the threshold of extreme injustice, legal certainty takes precedent over justice. Above the threshold of extreme injustice, however, justice takes precedent over legal certainty. Therefore, extreme injustice is no law, but normal injustice can be valid law. It is incorrect, but valid law. Legal certainty requires this. That is the first element on the pentagon, the Radbruch formula. Second element, the special case thesis. That is my oldest thesis, written down, standing in the center of my theory of legal argumentation. The second field in which the real and the ideal dimension of law are connected is legal argumentation. This connection is expressed by the special case thesis. This thesis states that legal argumentation or legal discourse is a special case of general practical argumentation or discourse. Legal discourse is a special case of general practical discourse because it is committed to statute, precedent, and legal dogmatics. These commitments, these obligations, represent the real dimension of legal discourse or argumentation. The ideal dimension comprises general practical argumentation. Habermas has argued against the special case thesis that it represents a blanket permission to move in the I quote Habermas, to move in the unrestricted space of reasons of general practical discourse. My reply to Habermas is that the special case thesis includes a prima facie priority of authoritative reasons. This prima facie priority, which is a necessary element of second-order correctness, finds inter alia its expression in the following rule of legal discourse. Whoever has looked in my book, Legal Argumentation, Theory of Legal Argumentation, knows that I always write down explicit rules. And this is one of my old rules I had not to change. Many old rules I had to change in the last decennia, but this not. I quote myself. Arguments which give expression to a link with the actual words of the law or the will of the historical legislator take precedence over other arguments unless rational grounds can be cited for granting precedence to the other arguments. The structure of this rule is quite different from that of the Radbruch formula, but its function is the same. Both serve to determine the relation between the real and the ideal dimension of law. And that is the title of my paper, The Real and the Ideal Dimension of Law. The third element of the Pentagon, human rights. The third area in which the relation between the real and the ideal dimension is of pivotal importance is the field of human and constitutional rights. Human rights are characterized by 5 properties. And I think that is the shortest definition of human rights we have. One sentence. Other people write books of hundreds of pages. I present only one sentence. Human rights are, first, moral. Second, universal. Third, fundamental. And fourth, abstract rights that, fifth, take priority over all other norms with respect to their moral validity. End of the definition. Here, only the first of these 5 properties is of interest: the moral character of human rights. And I would like to add the term human rights very often is applied in another sense. I apply it is the term only to moral rights. But, for instance, the European Charter of Human Rights in Strasbourg, the court in Strasbourg, are a positive law. They are international law. A covenant, a contract, they are transformed, moral rights transformed into positive law. That's important. But I use the pure concept of human rights as moral rights. I continue with my text. The moral character of human rights consists in their having, qua moral rights, only moral validity. This means that human rights as such belong exclusively to the ideal dimension of law. Now, a right is morally valid if it can be justified. Rights exist as norms in general if they are valid. Thus, the existence of human rights depends on their justifiability and on nothing else. And they are justifiable on the basis of this cause theory. But I will not present the justification here. It's very difficult. It's to justify the existence, that is, the validity of human rights qua moral rights, is nearly as difficult as to justify the existence of God. But it is, fortunately, a little bit easier than to prove the existence of God. And I have attempted some years ago to present at the World Congress of the International Union of Legal Philosophy, IVR, in Frankfurt. I gave the main lecture there and made the attempt to justify. We can perhaps in a discussion talk a little about it. But if they are not justifiable, as Kelsen says, then you can do everything. You can make positive law as you want, with or without constitutional rights. Now, we are concerned with the dual nature. In contrast to this, constitutional rights are part of positive law. Namely, positive law at the level of the Constitution. As such, they belong to the real dimension of law. The same applies to international contracts on human rights. They belong, the contracts, to the real dimension. The relation between constitutional rights and human rights, however, belongs to the relations between the real and the ideal dimension of law, because, now I connect both, because the claim to correctness establishes a necessary connection between human rights and constitutional rights and international rights. Constitutional rights interpretation depends on the understanding of human rights, and catalogues of constitutional rights may even be corrected. Catalogues corrected on the basis of human rights. For instance, in the German constitution, we have nearly no social rights. Only in Article 6, Section 4, the right of the mother to get help from the society. And I wrote in my theory of constitutional rights that the German constitution, the catalogue, is wrong. We must have a social right to an existential minimum. Some people, that was many years ago, some people suspected me to be a communist. For the Western world did not like social rights. But I'm so happy. In 2010, the German Constitutional Court adopted the theory that the German Constitution comprises a right to an existential minimum in spite of the fact that it is not written down. That is exactly the right way to connect the ideal and the real dimension of law. That is our theme today.
Lass mich mal das gerade übersetzen, weil das sehr wichtig ist. Traduzir esse punto que es super importante y siempre aparece en la discusión. En el libro sobre la teoría de los derechos fundamentales, Alexy fundamenta un derecho a un mínimo social para sobrevivir, básicamente, sin tener una base explícita en la Constitución alemana. En ese tiempo, cuando él lo fundamentó, había recibido mucho contraataque, contraposición, incluso aquí en Göttingen, de varios profesores, y lo han llamado comunista, porque reclama un derecho mínimo. El Estado tiene la responsabilidad de asegurar la existencia mínima de la persona. Después, la Corte Constitucional retomó esa postura, afirmó la postura de Alexy en una importantísima decisión, donde básicamente lo invierte, der leitet es ja auch aus der Menschenwürde ab, letztendlich das Verfassungsgericht, in der Entscheidung danach, que lo infiere de la dignidad humana, este derecho. Pero que Alexy fue el fundador, antes ya pensaba sobre ese derecho, y eso es muy importante en términos prácticos, no es solamente teoría aquí, es muy práctico en la implementación de la teoría alexiana en la jurisprudencia constitucional alemana. Okay.
That was the third element after Radbruch formula, and then the special case thesis, the second element, and then human rights, the third ideal element. And now the fourth element is democracy. And just to tell it to you, I have still one page. We can, in some minutes, relax. My fourth element is democracy. Democracy, at one and the same time, can be conceived as a decision procedure and as an argumentation procedure. Taking decisions in the manner familiar from the majority principle is the real side of democracy. Argumentation as public discourse is necessarily connected with the claim to substantive correctness. For this reason, it is the ideal side of democracy. And we have nowadays, everywhere in the world, problems with democracy. And that depends on a lacking connection between the real and the ideal dimension of democracy. The only possibility for the realization of second-order correctness in political life, especially in public lawmaking, is the institutionalization of a democracy that unites both sides. The name given to this unity is deliberative democracy. Habermas, as well as John Rawls, use this concept, deliberative democracy. I leave the rest. That was point 4 of the Pentagon. Now my last point, principle theory. 5. In the application of law, rules as well as principles play an essential role. Rules express a definitive or real ought, principles a prima facie or ideal ought. The principles of a legal system, taken together, constitute what might be called the world of the ideal ought. And this applies, for instance, very clearly to the principle of human dignity. The theory of principles, that is my main element of my theory of constitutional rights, attempts to develop on this basis a theory of proportionality that connects balancing with correctness. The nucleus of this theory are the two laws of principal theory, the law of competing principles and the law of balancing, explicated by the weight formula, a mathematical formula I have developed for balancing, as well as the rules connecting these two laws. This, however, cannot be elaborated here, for I don't want to start now with principal theory. I want to make clear the relation between the real and the ideal dimension in 5 aspects and the connection with the claim to correctness. This, however, cannot be elaborated here. In our context, the only point of interest is that principal theory completes the system of the 5 directions of the ideal dimension of law. Thank you very much for listening to me.